Nobody signs a car loan planning to end up in bankruptcy court. But file Chapter 7 while you still owe on the car, and sooner or later, somebody slides a reaffirmation agreement across the table and asks you to sign it. I'm Michael Goldstein. I'm a bankruptcy and foreclosure defense attorney in Massachusetts, and I've been handling consumer cases since 2006. A reaffirmation pulls one debt back out of your bankruptcy. You're generally telling the lender, don't discharge this one. I'll stay personally responsible, same terms as before. In exchange, you keep the car. Chapter 7 is a clean-out. Reaffirming is standing in the driveway saying, that one stays. There are decent reasons to do it. It generally locks in your right to keep the car as long as you stay current, which takes away any argument that your filing by itself was a default. Lenders also generally stop reporting a discharged debt. A reaffirmed loan usually keeps reporting, so those on-time payments may start helping you rebuild instead of sitting there invisible. And once in a while, a lender will negotiate the rate or the balance. Ask before you sign. That's the only moment you have leverage. Now, let's talk about the risk. A reaffirmed debt survives your discharge, and so does your personal liability for it. If the car gets totaled or the transmission goes at year 3, the lender can repossess it, sell it, and come after you for the shortfall. You generally can't wipe that out with another Chapter 7 for 8 years. And if you owe $19,000 on a car worth $11,000, reaffirming means you volunteered to pay $8,000 for nothing. The car doesn't know what you signed. Composite example, not a real client. Man in his 50s, works a trade, owes around $22,000 on a truck worth about $13,000. He assumed signing was the responsible thing to do. We ran both futures on a legal pad, and he surrendered. The shortfall generally gets discharged with everything else. Change 2 numbers. 18 months left. Truck worth more than he owes, and reaffirming is usually the easy call. Same document. Opposite answer. Signing isn't the only choice. You may be able to redeem the car by paying its replacement value in a lump sum under Section 722 of the Bankruptcy Code, or surrender it and generally discharge what's left. Before you decide anything, bring a current payoff quote, an honest value for the car, the repair history, and your real monthly budget after the case. Then ask your attorney straight out, given these numbers, would you sign this? There may be a legal opportunity you haven't considered, but it should be evaluated before time, money, or property is unnecessarily lost. If there's a reaffirmation agreement sitting on your kitchen table, schedule a consultation before the deadline runs. Link in the description. Attorney advertising. Educational only, not legal advice. Past results afford no guarantee of future results, and every case is different. We are a debt relief agency. We help people file for bankruptcy relief under the Bankruptcy Code.